However, it is doubtful. Whether it will be. Oh, sorry. Did I stop sharing? Sorry. Okay. It is doubtful whether this will be enough to attract SMEs to sandboxes and to offset these costs. As to the second issue, establishing and running a sandbox is a costly exercise, both in terms of financial and institutional resources, and both for innovators and the regulators alike. And this will be a challenge for small markets. So it is important also to emphasize that the prior reputation of a regulator plays a pivotal role in attracting businesses to sandboxes. And regulatory flexibility will not be able to substitute for the demand, but where there are resources, hopefully the demand could rise. Concerning the cost-benefit analysis, the question is whether Sandbox offers sufficiently informative evidence as to how the approved innovation is likely to work outside of the shielded environment, outside of the sandbox in the main market. And this scaling up of results is a well-known challenge. Companies will have to develop a clear vision and the plan how to explore those benefits within the sandbox and once the sandbox testing is over. Concerning diverging AI sandbox regimes, given that the AI sandbox regime under the Draft AI Act will be optional, left to member states for implementation, AI developers might be encouraged to do some forum shopping to choose those member states with less stringent sandbox regimes. This could also lead the regulators to the regulatory race to the bottom, which is not necessarily a bad news for SMEs, but it might be a gateway for bad and harmful innovation. There is not much guidance concerning the multi-jurisdictional AI sandboxes. How should they be implemented in practice? Cross-border sandboxes is an attractive option for small markets, but without standardization and in view of the harmonization required from different jurisdictions, I'm afraid that this may prove to be an unfeasible option. So can we learn some lessons from fintech sandboxes, which are already in operation and exist in various countries across the globe? Well, for example, when analyzing the viability of their sandbox model after the first year of application, the UK's Financial Conduct Authority, or the FCA, which is called as a sandbox pioneer, found clear evidence that the sandbox has been mostly popular with startups, whereas the share of SMEs and large companies was roughly equal. However, further findings show that companies who participate in the sandbox raise more capital because of their participation in the sandbox after entry. So with AI regulatory sandboxes, there might be more incentives for SMEs to participate should the EU follow through in its commitment to boost the competitiveness of SMEs. There are, of course, many more issues which we address more thoroughly in our paper, but I will stop here and leave room for discussion. So thank you for your attention.
Thank you, Professor Martinovic, for this timely placed presentation, a very interesting presentation. We should all bear in mind that when we talk about artificial intelligence, even though it is called artificial intelligence, it is actually still not yet artificial intelligence in the full sense of the meaning. But we should also bear in mind that such artificial spaces should be closely monitored and supervised. So to continue on with our next presenter, that is Dr. Meltem Karatepe-Kaya. I'm sorry if I butchered that. Assistant professor coming from Istanbul University, and she will tell us more about the topic of digitalization in corporate law from traditional to present and the way forward. You have the floor. The time starts now.
Thank you very much, Doctor. Hello, everyone. It's my great pleasure to welcome you to my presentation. First of all, I would like to thank everyone who contributed to this wonderful conference, and I would like to introduce myself briefly. I am Dr. Meltem Karatepe-Kaya. I am Assistant Professor in Commercial Law Department at Istanbul Medeniyet University. So, what is in my agenda today? I mean, what do I want to talk about today? Today, I will first give you information about digitalization and corporate law in general. Afterwards, I will give information about opportunities for corporate governance from AI and blockchain technologies such as AI Director and blockchain-based General Assembly or board meetings or trade registries. So briefly, I can say that I will talk about digitalization in corporate law from traditional to present and the way forward. The effect of digitalization on business is felt globally today. So digitalization is a key factor in the process from the formation of new companies to their dissolution, and also to advanced topics like implementing cutting-edge technology like blockchain or AI in companies are on the table today. So creation of this infrastructure has been attempted for years, as can be shown by looking at the theoretical foundation of the European Union. However, the effects of digitalization on companies have not been fully perceived, and many technologies have taken their place in companies before their legal infrastructure is built. For example, while legal systems were not ready, advanced technologies such as blockchain were used in companies to speed up procedures. And also we can see some examples of AI directors, even they don't have any legal status, which is recognized by the systems or the countries. And one of the most important issues that interests me is how new technologies can be used and adapted to existing regulations and company laws. Maybe the most challenging thing related to this contemporary topic is we have to study these topics and try to find solutions for possible problems which will exist shortly. I can say that. In the light of this short introduction, I would like to start to focus on impact of AI and blockchain on the corporate governance. First, if we start with AI, using AI in the corporate decision-making process gives rise to several legal discussions. The first concerns the appointment of AI as a board member. And as I said before, even though AI doesn't have a personality, it doesn't have a legal status, appointing an AI as a board member has already started. And the second discussion concerns the decision-making in corporations to AI and possible implications of this practice. And thirdly, third subject of discussion is about making decisions by referring to the results of AI's analysis of the data. Appointing AI as board members has not yet been fully vitalized, but leaving decision-making to AI or obtaining help from them in decision-making process is already very common in business practice. In many years, we are talking about corporate governance failures and solutions for those failures. And although the countries have prepared regulations, or European Union prepared some regulations and company lawyers have provided solutions, still we are struggling with some issues regarding those failures. So when we look at the main core principles of corporate governance, we can see that there are transparency, accountability, monitoring, equal rights, providing equal rights for the shareholders, all of the shareholders. And we are talking about the agency conflict between the managers and shareholders for dispersed ownership companies, and for concentrated ownership companies, we are stating that this conflict is between the majority shareholders and minority shareholders. So now we have a solution. Actually, it looks like AI might contribute to improve all of those corporate governance principles in companies, and maybe because of the help of the AI, we can reach a good level of corporate governance in all our companies. It looks like, since AI has a significant potential for the company's decision-making process, it can operate in a sector that can be handled remotely rather than by people, and therefore avoiding losses and gaining expert guidance. Actually, and AI appointed as a manager or director might help a firm to make better decisions by bringing a professional perspective to the management, and it might help to speed up operations. As stated by Armour and Ada Muller, there are many different areas. There are many numerous practical applications of AI in corporate functions, including information and communication management, investor profiling, product development, monitoring, compliance, decision-making regarding corporate strategy, investment, personal selection, and many other things. But AI in corporate governance and also AI in corporate governance has the potential to provide business with the next generation issue solving, market forecasting, risk management techniques. So I can say that AI may decrease the conflict between managers and shareholders because AI promises a good monitoring in the companies, and transparency will also improve because of the help of these AI systems. And it doesn't matter how we use AI in the company, whether as assistants or director. As I said before, there's no legal status for the AI recognized by the regulations. But already we can see some examples of AI directors. As you all know, all of the articles or the news about AI directors started with this example. There's one example in Hong Kong, which is vital. Appointed as a director in a company, deep venture company. Actually, when we look at the company law system, Hong Kong law system was not ready for an AI director. Its status was only an observer in that company, but it helped to take some important decisions at the end of the day. And also we saw some other examples. For example, in a Nordic company, Eclcg22 was appointed as a director in the company. So I can say that although legally they cannot be accepted as legally responsible managers in the companies because they don't have legally recognized personalities, especially Vital is known as first director in the world, and we can see its name on articles and other places about AI directors. But when we look at to the company law systems, even some countries are not ready for non-human directors. For example, for Turkey, we accept, our lawmaker accept legal entities to be a director in the companies, but some countries it's not possible to appointment of a legal entity as a director in their board of the directors in companies. So we, as a corporate lawyer or for a corporate law system, there is a need for somebody who are accountable for their actions and can be held accountable for their harm to the organization. Leaving aside the discussions about the legal status of AI, I can say that many countries are not even ready for non-human directors. Today, I don't want to focus deeply on personality discussions as a corporate lawyer because it's not our issue, I think, but I can just say that EU has taken serious steps about determination of responsibility of AI. But even if I don't want to speak about legal personality or other issues, as a corporate lawyer, there are still many difficulties in appointing an AI to the corporation's board of directors. Since company law rules were created by considering human board members or members who will be responsible for the actions in that board, company law requires directors to be honest and act in good faith, which is only expected to exist for humans in performing their duties. So AI directors can make more rational decisions than human managers because of their design. Ultimately, this subject is not human. AI is the product of human-made technology. Therefore, it's pointless to think that AI will take the initiative or behave in good faith like humans. Yes, AI can be more professional, full-time employees as board members than humans. However, it is also challenging to expect AI to work with a human director's potential at this stage. Eclcg also claimed that if AI were to take the role of human populated boards, the options available to shareholders would be no better than they are today. As a result, the rise of AI requires corporate law to reconsider some of its ground rules to test its suitability for artificial intelligence board members. When we claim that the AI director would add a professional viewpoint to the company's management and streamline the operations is debatable due to the fact that it may be considered to benefit from the AI director for the reduction of agency costs. However, the presence of AI bias and prejudice should not be overlooked, since the AI director's judgments will be influenced by the designer or developers due to the AI system's current nature. For example, an AI director which is appointed to the board of directors in order to become more professional may work with the majority owners of the firm to merge the minority shareholders' rights and interests. I think the problem here, for example, maybe we can replace a director with AI could also end the position of the independent directors in the companies. But when advancing this idea, AI's bias and discrimination problem should not be forgotten. I think the problem is, I am looking for the presentations and some articles, and I can say that people are talking about the replacement of AI with, for example, directors or the judge or arbitrators. But the problem is, if we trust so much those technologies, we can lose our control, and we have to keep in mind that we have to be careful that those technologies also have their drawbacks. For example, for AI, the problem is if we forget the discussions, the issue of bias and discrimination problem of AI, then we can trust those technologies so much, and then we can establish our new systems by losing our control mechanisms. As some scholars said, maybe we can find solutions for corporate governance problems in our companies, but we might have some other problems which will not based on human behaviors, but which will be maybe more risky and more important than today. Okay, of course, we have to comply with those technologies. We have to adopt those technologies to other for example, companies, but also we need to set up some systems to avoid from those technologies drawbacks, disadvantages. For example, we need to put some compliance mechanisms for the other managers, for other employees of the company to adopt those new technologies. So we should, even if we use AI as a director or assistant in our companies, we need to provide some control mechanisms. And I can say that as a result of those AI director or AI using AI in companies, AI is getting closer to becoming a board member day by day, but AI has already become an essential enabler of directors' decision making. And we have to know that benefiting AI in the companies has some advantages and disadvantages as well. So we have to be careful about those things, and then we need to be ready for those systems. Another system which is more, it looks like it's more possible to use for now I think it's a blockchain systems. Normally, most of the countries benefit from the digitalization for the corporations, particularly non-physical, the electronic or virtual meetings are seen in the many countries in the world, and in Turkey as well. We have electronic general meetings. Regarding other technologies, for example, when we look at the advantages of non-physical meetings to the companies and shareholders' rights and eventually corporate governance, which has been implemented for years and is even one of the first example of the practice in the world is held in Turkey. But today I would like to talk about the way forward and focus on whether it is or it will be possible to develop general assemblies with blockchain technology, including smart contracts or DLT, distributed ledger technology, by taking electronic boards that are not physically made one step further.
Sorry.
I will like to keep it short, and I will.
Yeah, your time has run up, so please, could you please wrap it up?
Okay, today we might have electronic meetings, and also we might establish our companies from the foundation to the dissolution by blockchain systems. I think it might help, especially for shareholder engagement, and it might help to improve our corporate governance in our companies. It might help transparency. It will have many advantages, but we have to be careful about, again, some drawbacks of those technologies. For example, there is a right which is given by the GDPR to the persons, legal and real persons. It says that the persons have a right to be forgotten, right to be forgotten by the other parties. So those blockchain systems have some issues related to this right. And also there's some energy consuming problems. I can say that even if we get benefit from those systems, even if we get benefit from AI and blockchain, at the end of the day, we might have some problems. So we have to be careful about those problems. And we have to be ready for the future of corporate governance. Thank you for your patience and thank you for listening to me today.
Thank you for your presentation. I just want to point out that at the end of all of the presentations, we're going to have hopefully some time left for further discussions or questions or similar discourse with the audience. And on the topic at hand, yes, the topic is very interesting, but we should all know that AI is still not autonomous. It is a written program, meaning that it is as good as its creator, the developer, and such developer could hardly account for all the issues that might arise in the company, which might seek attention of the board members. So without further ado, next topic at hand is one from Professor Eclcg22, my apologies, on the topic of company liability for the processing of personal data incompatible with the principle of purpose limitation. From Romania, you have the floor.
Thank you. Good morning. So the topic of my presentation today relates to the company's liability for the processing of personal data incompatible with the principle of purpose limitation, a topic which continues to generate provocative controversies, especially from the perspective of detailing the data processing purposes and operations taxonomy for the personal data controller. Firstly, the study approaches the limitations related to the sequencing of processing purposes in situations where the collecting and processing of personal data is based on the existence of consumers' consent. So the stratification of personal data processing purposes, as well as the stratification of consent for each type of processing operation, represents special requirements arising from the condition of granular consent, implying that consumers' consent requested in general terms will not be considered valid for any personal data processing operation or for the so-called purposes related to the execution of the contract without an explicit statement and distinct statement for each of the data processing purposes. So the so-called sequencing of the processing purposes is essential. Secondly, the granularity rule is discussed in relation to the exigencies of the principle of purpose limitation when collecting and processing personal data, and when distinguishing between the imperatives deriving from the principle of purpose limitation from those arising from the incidence of the principle of storage limitations, for instance, including in terms of post-verification of the processing purposes. Thirdly, the study discusses the limits of the purpose limitation principle as set out in Article 5, the first paragraph, letter B of the GDPR, including bifurcated components. Personal data must, on one hand, be collected for determined, explicit and legitimate purposes, and on the other hand, not be further processed in a manner which becomes incompatible with the initial collecting purposes. So we argue that the mentioned principle aims to delimit as clearly as possible the use of personal data by ensuring a balance between respect for the fundamental rights of data subjects in terms of privacy and data protection, and the recognition of a certain flexibility in favor of the operator in the management of such data, as imposed by digitalization and its inherent risks. And in its second component, which is of particular interest to us in this present study, the purpose limitation principle seeks to define the extent to which personal data collected for a particular purpose may be reused by the companies, since any processing after collection must be considered as further processing and must therefore meet, with certain exceptions, the compatibility requirement. So the latter reflects the exigencies of a concrete, a logical and sufficiently close link between the purpose of data collection and further processing, requiring that this processing must not be disconnected from or must not contradict the original purpose of the data collection, and its content must be reconcilable with the rationality of the collection of data, regardless of any temporality issues. So the principle of purpose-related limitations is not a mere reflection of an expression of the principle of proportionality. Unlike the principle of storage-related limitations set out in Article 5, the first paragraph, letter E of the GDPR, particularly the granularity of data processing agreements requires for a separation of information on the data processing agreement from the rest of the information provided to consumers in the pre-contractual stage, as well as the implementing of the opting-in system for requesting consumers' consent, since general regulation establishes the exigencies for an opting-in system, which includes an opting-in agreement and excludes the validity of consent where passive behavior or lack of consumers' reaction could be speculated by data controllers in the sense of assuming the content and the existence of the data subject's consent to the collecting and processing of personal data. Absence of the consumer's reaction, as well as the failure to initiate an action on the data subject's part, or the simple omission of selecting the options regarding the processing of personal data, do not represent legal grounds for the respective operations, and the consumer's consent in this case is practically in existence. On the other version, the valid consent expressed for the processing of personal data requires an unambiguous expression of will by means of an unequivocal statement or by a clear affirmative action of the data subject, which implies that the data subject has taken a deliberate action to consent to each type of data processing, tacit or implicit consent based on consumer silence or inaction of the data subject does not in itself constitute unequivocal consent to personal data collecting and processing. So in this parameter of deciphering the specific conditions for the validity of consent to the processing of personal data, looking at the statistics for the last year, the study aims at potentially answering interrogations such as which salient elements are indispensable for collecting consumers' consent, on the basis of which the free and untainted nature of the consumer's consent to the processing of personal data by trade and service professionals in business-to-consumer contracts can be estimated. Are the provisions of Article 4, the 11th paragraph of the General Regulation 679, are these provisions sufficient for such elements to be deduced? Particularly, it can be argued that consumers' freedom to opt for choosing or refusing the collecting and processing of personal data implies the controller's respecting of the real choice exigencies and the possibility of exercising real control by data subjects over the collected data, since the data subject's consent may be discretionarily withdrawn. In cases where the data subject does not benefit from a real choice or feels constrained to accept to the data processing by the controller, or there is a fear that the data subject will suffer negative consequences should they later refuse the data processing, the consent will not be validly expressed. Similarly, a blank acceptance of the general terms and conditions cannot be seen as a clear affirmative action of consenting to the use of personal data. So the provision of the General Regulation 679 do not allow personal data controllers to provide pre-checked boxes or methods such as self-exclusion or voluntary exclusion of consumers from the processing of personal data, the opting out consent, while prohibiting the means of presuming the existence of data subjects' tacit consent, which require an intervention by the data subject to refuse the agreement, the opt-out boxes, and which rely on the silence of the data subject's passivity or non-assertively acceptance are inexcusable. So finally, the study emphasizes the fact that there is no perfect synonymy between the granularity of the processing purposes rule and the principle of specificity of consent to the processing of personal data. Certainly, the condition of the specificity of the data subject's consent cannot be deciphered in the absence of an analysis of the notion of granularity of consent, which significantly enhances the meanings and valencies of the first principle. Yet, are they synonymous, or in reality, do these two phrases cover distinct, autonomous and conjugately applicable conditions in assessing the validity of consumers' consent to the processing of personal data? We argue that the answer to the question is negative without being synonymous. The two expressions cover two distinct attributes that the consent required for the consumer to process personal data must meet. So the specificity of consent is the opposite of generalizing or admitting as valid the consent to the processing of personal data for unspecified purposes, while the granularity of consent implies that data subjects have the freedom to choose the purpose they accept without being forced to accept the full package of purposes for the data processing and to be able to exclude some of these purposes. Moreover, in hypotheses in which the procedure for obtaining consent does not allow the data subjects to give separate consent for the various personal data processing operations or for different purposes of the processing, the very requirement of freely expressed consent would be seriously affected due to the element of constraint, which becomes present in such hypotheses. So such a corollary of the freedom of consent and the specificity of the data subject's consent, the granular nature of consent is seen as an indispensable condition when processing personal data for multiple purposes and requiring the solution to meet the conditions of validity of consent in terms of respecting the granularity of consumers' agreement and obtaining separate consent for each of the processing purposes panoply mentioned by the data controller. So in terms of establishing consumers' capacity to adequately understand and calibrate consent to multiple purposes of data processing, it should be emphasized that as resulting from the CGU decision from 11 November 2020, in case C61/19, the data controller must demonstrate that data subject has, by active behavior, given his or her consent to the processing of his or her personal data, and that he or she has obtained information relating to the circumstances surrounding the processing, obviously in an intelligible and easily accessible manner, using clear and plain language, which allows the person easily to understand the consequences for that consent, so that it is given with full knowledge of the facts. So as regards more specifically the data subject's possible consent, it resulted that during the procedure for concluding the contracts at issue in the main proceedings in the mentioned case, the data controller's sales agents did not inform the consumers concerned before concluding the contracts on each of the purposes of collecting and storing copies of the identity documents and of their choice as to that collection and storage before obtaining the consent to the collection and storage operations. And in fact, the box relating to the storage of copies of identity documents was pre-ticked solely on the basis of the so-called presumed consent of the individuals in terms of agreeing to the so-called implied purposes of data storage, such as the storage of personal data for the purpose of further enforcing the creditor's rights against the debtor in the eventuality of payment delays. So to conclude, in situations where the processing of the consumer's personal data is aimed at direct marketing, the data subject has the right to object at any time to the processing for this purpose of the personal data concerning the data subject, including the creation of profiles, insofar as it is related to the direct marketing purposes. So if the data controller provides different services, sufficient granularity will be needed to ensure that different purposes are sufficiently clear for the user. So oversimplification should be avoided. Thank you so much for listening to my presentation.
Thank you for staying on time primarily, but also thank you for your very interesting presentation, which shows us that we are going to have some form of regulation, for example, GDPR and its protections with us for quite some foreseeable time in this, or even, I presumably, even more developed form. And we all know that personal data is becoming a very important and lucrative business resource for many businesses, including those whose core business is not primarily data processing. So let's continue on with the next presentation from Professor Kaya from the University in Istanbul, Turkey, on the topic of blockchain dispute resolution for decentralized autonomous organizations. You have the floor.
Thank you, Professor. Could you hear me?
We hear you.
Yeah, thank you so much. Good morning. Maybe I should say good afternoon, depending where you are. Distinguished colleagues and guests, it's my great pleasure to present my work today. Before starting my presentation, I would like to express my warmest thanks to the organizer of that conference. Let's start my presentation. Today, I'll talk about blockchain dispute resolution for decentralized autonomous organization. When we look at my agenda today, firstly, I will talk about what are DAOs and why we need it and how does DAO work, and then I will go more deeply more on the issues and disputes relating the DAO and especially enforceability and jurisdiction issue, and then I will talk more about how we can resolve the dispute arising from DAO. Let's start with the definition of DAOs. Today, we are at the forefront of a whole new transformation of digital space. I mean, we are entering into blockchain nowadays. Every presentation is about the digitalization, blockchain. When we look at the big companies such as the Google, Amazon, Meta, Apple, Microsoft, all they have grown up on the internet and giving a small number of people a lot of power. On the other hand, when we look at the blockchain technology, it promises to redistribute the power of any central institution among the hands of many people. The rise of Bitcoin has already changed how people send money to each other. Smart contracts are about to change the way people make agreements by code. I mean, by writing the terms of their deal into a blockchain. This makes it possible to automate the transfer of capital under predetermined conditions. Building on the design of smart contracts, the blockchain environment is now giving rise to new kinds of entities, which is called decentralized autonomous organization. So the most of them are based on the blockchain. I mean, since when we look at 2020, over 1 million transactions have occurred on the Ethereum blockchain every day. This significant level of digital commerce is conducted almost entirely by smart contract or self-execution parts of computer code that immediately transfer assets between parties. I can easily that these automatic, irreversible contracts are one of the Ethereum most significant inventions, providing us a virtually cost-effective, I mean, costless and faster contractual enforcement mechanism. Of course, despite such advantages, pre-coded agreements face a number of legal, practical, and governance-related, I mean, management issues. It is clear disputes regarding DAOs are inevitable, and parties will need means for dealing with DAOs issue, since there are some practical ideological disconnection between smart contracts and traditional legal proceeding. The current traditional litigation system do not present a viable method for resolving those disputes. So today I will analyze these challenges, analyze the leading online dispute resolution for, I mean, emerge for resolving DAO's dispute. When we look at the definition of the DAOs, the civil reward defines DAO, as you can see in the presentation, as the entity created by the deployment of an autonomous and self-execution software running on a distributed system that allow a network of participants to interact and manage resources on a transparent basis and in accordance with the rules defined by the source code. I mean, those are the new kind of the entities that are used to coordinate an economic and social activities on the blockchain. I mean, it is set up and run by the codes, and which they are written in the computer software, which we are calling that smart contracts. There are many, I mean, definitions. So, but as I said, you know, there is no, not a single and universal definition of DAO. So there are many. So, but we can say it's a new kind of entities which is based on blockchain. There are some current example of DAOs. For example, MakerDAO, MakerDAO, Bankless DAO, all have different purposes, from governing the issues of the funds against a crypto collateral, funding grant purposes for different projects, also being a collective of guilds that members vote on decide different objectives, undergoing collective development projects, or organizing around the fashion and culture that creator members pursue. When we look at how does a DAO work, a DAO launch occurs in three major steps. The first step is smart contract creation, which means that developer or group developers must create a smart contract behind the DAO. After the launch, they can only change the rules set by these contracts to the governance system. That means they must extensively test the contract to ensure they don't overlook important detail. The second one is after, the smart contract have been created, the DAO needs to determine a way to receive funding and how to enact governments. More often than not, tokens are sold to raise funds. These tokens give holders voting right. The last stage is, after everything is set up, the DAO needs to be deployed onto the blockchain. From this point on, the stakeholders decide on the feature of the organization. The organization creators, those who wrote the smart contract, no longer influence the project any more than other stakeholders. Why we need DAOs? Being internet native organization, DAOs have several advantages over when we look at the traditional organization, where the most significant advantage of DAO is the lack of trust needed between two parties. While when we look at a traditional organization, they require a lot of trust in the people behind it, especially on behalf of investor. When we look at DAOs, only the code needs to be trusted. We don't need to trust investor, because we need to trust the code. Trusting that code is easy to do as it is publicly available and can be extensively tested before launch. Every action a DAO takes after being launched has to be approved by the community, and it is completely transparent and verifiable. Such an organization has no hierarchical structure, yet it can still accomplish tasks and grow while being controlled by stakeholders through its native token. The lack of hierarchy means any stakeholder can put forward an innovative idea that the entire group will consider and improve open. International disputes are often easily solved through the voting system in line with the pre-written rules in the smart contract. By allowing investors to pool funds, DAOs are also giving us a chance to invest in early stage startup and decentralized projects while sharing the risk or any profits that may come out of them. When we look at disadvantages, of course, they have many advantages, but they are not perfect as smart contracts. They are an extremely new technology that has attracted much criticism due to lingering concern regarding their legality, security, the structure. Those can be circulated across different localities, and there is no legitimate structure for them. Any lawful issues that might emerge will probably require those required to manage various territorial law in a concomitant fight in a court. Currently, I know that there is 3 different jurisdictions. Malta, Vermont, and Wyoming. If you know more, please let me know. Have introduced the most prominent legislation allowing DAOs to be operated within a legal framework. The second one is because if you buy the tokens, you can be stakeholders. So it means that there are many token holders. So it often takes longer for the decision to be made as there are more voting participants. The last one is the security. DAO can be launched with just a few lines of code and given the immense tech stack a well-run DAO requires to operate efficiently. So security remains a vulnerability as it requires a significant technical expertise, and it is expensive to keep best security practice implemented. When we look at, as I said, those are entities that are one of the best suited for doing business in the blockchain environment. The majority of their activity is carried out on the blockchain through smart contracts, of which 2 types can be distinguished. The first are smart contracts that are linked to an underlying legal contract where the smart contract serves to perform one or more contractual provisions, or where the smart contract is reproduction of the legal contract, which is legally binding upon the parties. The second are smart contracts that are legal contract themselves and no links exist with underlying contract. In theory, DAO smart contracts sound efficient and perfect, but there are several problems related to their implementation. Because most of them are based on smart contracts assume ideal actor, economic intensive, and perfect legal settings, but they might not always be the case. So the problem can be arise from I mean the DAOs, especially we can ask who is responsible for coding errors, or if the system malfunctions due to certain conditions. Two biggest legal problems of DAO and smart contracts lie in their blockchain provenance. The first one is enforceability of DAOs and smart contracts. Blockchain came into mainstream prominence as a decentralized and permissionless system that can be used to speedily conduct business transactions between multiple geographies. Current dispute resolution of contract differs from the countries and is settled in court, but blockchain works in opposite manner. As you know, the consensus for a transaction is a function of agreement between multiple nodes in a network that, in a complex system may reside in multiple geographies. How will a decentralized system arrive at a consensus regarding dispute among stakeholders? Permissioned blockchain have a line of authority that help resolve dispute, but these typically operate within private enterprises. For permissionless blockchains which operate with the public realm, the problem is still that. There is also the problem of jurisdiction. How will dispute involving DAO for international transactions, smart contracts that span multiple geographies be resolved? More specifically, will the different jurisdictions involved have to work in concert with each other to piece together a judgment or resolution to disputes? The problem becomes further complicated when you consider the legal status of blockchain smart contracts DAOs. Some states have taken the lead recognizing DAOs, smart contracts, while are still arriving at an understanding of technology and its application to their society. The varying interpretations of DAOs with respect to blockchain could also present their own set of problems. Despite early promises, a dispute-free environment, because smart contract DAOs are promises are as a dispute-free environment in which transactions are irreversible and executed automatically. Eventually, it began to be asked, what about dispute resolution? Experience with blockchain-based endeavors in recent years has shown us that blockchain, as any other area of human engagement in a rapidly evolving complex settings, is bound to generate misunderstanding, conflict, and unforeseen circumstances. Within a few years, enterprises start seeing the potential of online dispute resolution for the blockchain area, because ODI is conducted online far from afar and allows for flexible design and a global research. Now I will give explain a description of some of the principal system and process that emerged in the last couple of the year for blockchain resolution. Developers and yes.
Sorry for interrupting. Your time has run up. Maybe you could just try to wrap it up.
Okay. There are some startups. When we look at the Claros founded in 2017, they proposes a blockchain-based online dispute resolution for, dispute arising from smart contract. They are more focusing on operation of the smart contracts, and then when a dispute arises, they are trying to resolve the dispute as well. Also, there are the juries and jury online. There are some, problems regarding the startup, because if you want to be the jury in that system, you need to buy tokens. If you buy more tokens, it means that you have the more chance to be arbitrated in the system. So just I'm concluding, smart contracts and blockchain DAOs are growing very fast, but for now, maybe they represent only a tiny portion of the massive billions global legal marketplace. The sound is perfect, but disputes are inevitable. Decentralized justice industry, blockchain-based online dispute resolution is still in its early stage. So traditionally, the litigation system doesn't meet the requirement of, resolve the disputes based on blockchain. So we need to a new dispute resolution based on blockchain. Thank you. Sorry for, exceeded the time.
It's not a problem. Thank you for your very interesting presentation. What I can gather from my own knowledge and from your presentation is that DAOs seem to be some kind of a next-gen upgrade of the smart contracts. In this regard, it seems that DAOs represent similar technological limitations as companies run by AI board members, as well as those relating to technological limitations like the expediency of decision making. But DAOs have also many potential advantages, especially in regard to lesser costs once the technology is completely established and so forth. We are, of course, yet to see where the blockchain dispute resolution mechanism DAOs in this regard will take us in regard to resolution or making the kind of dispute resolutions situations. So without further ado, let's continue on with our next presenter, which is a researcher at the Law School of Legal Tech Center of Mykolas Romeris University, Mr. Romashchenko, who will tell us more about the digitalization of company law in Ukraine from a comparative perspective. You have the floor.
Thank you. Thank you very much for giving me the word. And in general, I would like to express my deepest pleasure to talk today at today's conference. Yesterday, it was also a great day full of inspiring and interesting speeches and presentations. And as well as today, I deeply enjoyed the presentations and speeches which were in our panel. So thank you for that. And let me first shortly tell me about the project that I perform with my research supervisor, Professor Dr. Virginijus Bite, who is the director of the Institute of Private Law and professor at Mykolas Romeris University. Our project is called Digitalization of Company Law, Harmonization Challenges and Opportunities in Selected Jurisdictions. In our project, we focus mainly on Lithuanian law and in some selected jurisdictions. But today I will, in my presentation, I will focus mainly on Ukrainian law perspective in comparative context with the EU and with the implementation of the digitalization directive in Lithuania and in such jurisdictions as Estonia, Latvia, and Poland. So this is my presentation plan. I'm going first to talk about the developments of digitalization in Ukrainian company law, then talk about comparative perspectives, and then move to conclusions and recommendations. So first of all, we have rules in Ukraine about online formation of companies, and those rules were adopted in 2015, which there was a statute allowing online registration. In 2011, we had model articles of association for limited liability companies, or in Ukrainian Товариство з обмеженою відповідальністю, approved in 2011, and then some time passed when in March 2019 the online registration for private companies was launched through DIA. I have to say that in Ukraine, as as it is in many other jurisdictions, limited liability companies is the most famous and popular form of companies because they enjoy very simplified formation, such as minimum share capital, 1 hryvnia, a few conditions to be stipulated in the articles, and simplified governance structure. So it can be one-page articles of association, basically. That's why it's and other features make it an attractive business form. What is necessary for the online formation of company in Ukraine? First, a person has to authorize on DIA portal. There's also an app on smartphone called DIA. It's very handy, and it can be done using bank IDs, qualified e-signature, and DIA PITPAS. But in any case, in order to finalize online formation, a qualified e-signature is required. And I have to say that next year, in April, Ukraine will launch the e-residency for foreign residents, the same thing as Estonia has now. And so foreigners will be able to easily establish online companies in Ukraine because they will receive such e-residency and tax code and etc. So this is what we have today. This is a graph showing how online formation proceeded. So actually here I should make a short remark. You can see that starting from 2019, there were a gradual increase in information using model articles of association. However, model articles of association does not necessarily mean that it was online formation, because also companies could be formed using model articles of association through the register. That's why, of course, these data do not show exactly the online formations, but still we can say roughly that model articles their popularity are increasing rather than just paper articles used certified through a notary. So as for other aspects of digitalization, corporate governance, we have regulation for private companies starting from 2018. Shareholders in private companies can participate by video conferences in general meetings of shareholders, and also decisions at general meetings of shareholders can be taken by preliminary and survey voting. However, there are no rules for hybrid general meetings of shareholders where shareholders can participate online. As you know, there are two types basically of shareholder meetings from the digital point of view: totally virtual and hybrid general meetings. So we have rules in private companies for totally virtual, but at the moment there are no rules for hybrid general meetings. As for public companies, we have a new law on public companies, which was adopted in July, which allows first electronic voting and electronic virtual general meetings, which through the specially authorized system, which will take effect after 1st January 2024. But already we have remote general meetings, which are performed by sending bulletins, and in case they are held, in case they are allowed by articles of association. However, at the moment, during the war, only remote general meetings are allowed, and the same thing we had during COVID-19. So remote general meetings, we have the experience of remote general meetings of shareholders starting from COVID-19 times. As for meetings of other corporate bodies, in private companies, we don't have any rules for hybrid or electronic virtual meetings of corporate bodies, while for public companies there are rules for such bodies as supervisory board, board of directors in case of one-tier system, or supervisory board in case of two-tier system. They can be held either by audio or video conference. As for Lithuania, I'm moving to more comparative overview. So in Lithuania, the online formation of companies started in 2010. And today qualified e-signatures are issued in Lithuania by the State Center of Registers, by the Identity Documents Personalization Center, or Lithuanian mobile operators. The same thing in Lithuania, there are model founding documents, and the online formation is available to Lithuanian limited liability companies, or UAB, but also to some other legal entities such as small partnership, individual enterprise association, public institution, and some others. And in 2021, there were amendments which were implementing the digitalization directive. Although the online formation was available long before the digitalization directive was adopted in 2010, there were still some nuances, some changes that had to be made, and they were adopted in 2021. This is a chart showing how online formation became more and more popular in Lithuania. So as you can see, in the beginning in 2010, around 1.5% of registration were online registrations of limited liability companies, while now, well, in 2021, the percent of registration of online registration is more than 84%, and well, it is growing. As for corporate governance aspects in Lithuanian companies, we can see that in all kinds of companies, in private companies, public companies in Lithuania, shareholders have the right to vote by electronic communication, and also there are provisions allowing electronic voting for members of supervisory boards and members of management boards. Also, within our project, we carried out a survey trying to understand the perception of digitalization, digital aspects of formation, online formation, and corporate governance from the business sector, from law firms. So we sent our questionnaire asking for, first of all, to outline any issues to 15 law firms and 25 company registration agencies. So we received 13 answers, 4 large firms and 9 small, medium-sized firms answered. And there were many answers, but I'm not going to stop on all of those answers, only to summarize some most important, I think. So in general, the law firms indicated that there is a need for broader use of various means, identification means. Some respondents opined for more flexible and detailed template. Some well, complained about the potential barrier that the opening of a bank account for a foreigner needs more time when we are talking about online formation. Although I have to say that we also interviewed the Center of Registers, and the Center of Registers told us, informed us that already there were implemented mechanisms to overcome this issue. And there were some technical remarks. But in general, despite the issues, most respondents consider the legal regulations suitable and effective. As for corporate governance feedback, respondents said that organization of the meeting is not described in detail, and opined that more scrutiny of e-communication tools, identification of shareholders, and formalization of meetings is necessary. And some respondents experience issues collecting e-signatures of shareholders. But in general, still, most respondents found the regulation sufficient and effective. As for more general overview of jurisdictions, so we what I saw in all jurisdictions, including Lithuania, Ukraine, Estonia, Latvia, and Poland, all selected jurisdictions have experience of online formation of private companies using templates of constituent documents and qualified e-signatures. However, if we compare templates that are approved today in Poland, Ukraine, and in Lithuania, Latvia, Estonia, in Poland, Ukraine, the template is more like box where there are many options, and you can select many of those provisions. While in Lithuania, Latvia, Estonia, it is more a standard document. Well, there can be different opinions of what is more preferable, and I think there's a path dependency, of course, but in general, in every jurisdiction, we saw that every jurisdiction favors its own template, more or less. In Estonia, by the way, there was an interesting solution for, and there is an interesting solution for a foreigner, for foreigners opening their companies, the possible delayed formation of share capital. So in case, for example, of course, forming share capital, opening bank account always takes time. And so in Estonia, they allow delayed formation of share capital, which is, of course, combined with some legal consequences, such as shareholders' liability for outstanding obligations and prohibition of distributions and share capital changes. So this is the case of Estonia, but again, in Lithuania, Lithuanian authorities implemented other solution by requiring the bank documents from other jurisdictions, from other banks, from other countries. So it's can be another mechanism. As for corporate governance, well, what I saw, and I think it's more or less widespread in all jurisdictions, electronic participation is in hybrid general meetings was allowed and is allowed in Estonia, Latvia, Lithuania, Poland, while in Ukraine so far only for public companies. Although in Ukraine it is allowed only for public companies, there are in private companies virtual general meetings and options of preliminary voting and voting by survey. So talking about the conclusions of our research, I mean, this is not the conclusions of the whole project which we perform at Mykolas Romeris University, but as far as recommendations for Ukrainian company law are concerned, first of all, we saw and we can see that online formation is available in all these selected jurisdictions. And as for recommendations for Ukraine, of course, this is not the most important thing for Ukraine now. We have other more societal challenges which we need to face. But I think that the digitalization directive can be useful for Ukraine in, for example, making the template available in language broadly understood in the largest possible number of cross-border users, which is a provision of the directive. And one recommendation for Ukrainian company law can be, which also is inspired by the feedback from Lithuanian law firms, is that more detailed regulation of electronic, virtual, and as well as hybrid general meetings of shareholders and other corporate bodies in private companies is needed. So, for example, more detailed regulation on the tools to participate in meetings, more sophisticated identification of participants, and formalization of meetings. I have to say that, especially as far as I'm finishing my presentation, this is my conclusions. So as far as identification of participants is concerned, there can be really practical situations when, for instance, if there is no conflict in a general meeting and there is a virtual shareholder meeting, there's no problem. But if, for example, one shareholder is somehow want to contest the general meeting of shareholders and it was a virtual meeting, then it is difficult to prove the fact that all shareholders were properly identified during the meeting. So this should receive more regulation. So just a short note about our research, and thank you for your attention. If you have any questions, I will be glad to answer those. Thank you.
Thank you for your presentation. Your topic reminded me of a situation during COVID lockdown, at least the first part of your presentation. Situation during COVID lockdown in early 2020, where many PLCs could not hold their assemblies due to limitation of a number of shareholders available in one room. So in Croatia, you can have a digital General Assembly other than compliance, other than complying with other technical conditions, under condition that such a possibility is permitted and envisaged by the company's articles of association. Presumably, very few PLCs had such a possibility included in their articles of association, and the problem had to be solved creatively. So it was kind of interesting to see those creative solutions, but hopefully, I mean, at least some good out of the COVID situation for us was that companies started to look into other ways of trying to do these corporate governance, internal corporate governance things by themselves. So thank you very much. We are moving on to our last but not the least presenter, Mr. Jakub Brejdak. He's a PhD candidate at the University of Warsaw and a visiting researcher at the UCLA, who will tell us more about crowd investors protection mechanism under regulation 2021-1503 on European crowdfunding service providers for business. So, Mr. Brejdak, the floor is yours. You have 15 minutes.
Thank you. Thank you for the invitation for this panel about digitalization of company law and related areas. And I will be talking about one of those related areas because it's more about digitalization of finance, which it's the main driver for equity crowdfunding development. But law reflects those changes and also reflects the digitalization of finance. So yeah, I want to focus today on investor protection under the regulation on crowdfunding, which entered into the force last year. And firstly, I want to give some short characteristic of equity crowdfunding market, because this characteristic will imply some protection solutions that were implemented in this regulation. Then I will go through categorization of investors, because that's the launching point for investor protection in general in financial markets, and there are some differences between this regulation and MiFID II. Then I will list briefly those main mechanisms which I identified and which I described in detail in the already submitted paper for the special issue of the journal after conference, but because of the time constraints, I want to focus on one particular, which I think is very interesting and wasn't widely deployed in finance, in investment space mechanism. By this I mean cooling off period. So going to the short characteristic of equity crowdfunding market. So yeah, crowdfunding services provide an unconstrained pool of investors who all receive investment proposal at the same time, and they mainly entail the raising of capital from individual people, including those who are not high net worth individuals. The literature often highlights that crowdfunding is cheaper and more accessible source of capital for companies than traditional sources. Nevertheless, as the majority of crowd investors are unprofessional, many risks are more significant to that group than to the traditional retail investors. Inexperienced individuals who are distributing capital in crowdfunding are making decisions based not on the same factor as institutional investors, which is obvious, but their investment decisions are often based not on the expected capital return, but for instance, on the need to show support and endorsement to the mission or values or a particular project. So research showed that crowd investors often at the same time are also consumers of products and services provided by the companies in which they invest, which create also a very special relation. So in the view of the above, the EU regulation has an important goal to achieve with investor protection mechanism, because on one side it needs to balance or provide a suitable level of protection and reflect to their risk appetite that is inherently associated with financial markets. As we know, the fundamental investment protection mechanisms for general financial market are included in MiFID II. However, the early years of crowdfunding practice in Europe proved that equity crowdfunding escapes from the traditional financial market conventions. That's why some member states implemented their own specific regulations on crowdfunding, and as a result, crowdfunding platforms were subject to a variety of national regimes, and there was a need to harmonize those rules to booster also cross-border equity crowdfunding transactions, and that's the main aim of the regulation. And if we will go to the launching point of each analysis of investor protection, that's the categorization of investors. And crowd investors, similarly to traditional investors, are not a homogeneous group. So the divergence in experience and held assets between investors in crowdfunding can be, and it is significant. Those differences are significant. That is why the EU regulation introduces the main distinction of crowd investors into two categories: sophisticated and non-sophisticated. This regulatory solution aims to match the degree of protection of the investor in a manner adequate to his or her knowledge and expertise in financial markets. And as we see, this distinction is patterned after the distinction for professional clients and retail investors from MiFID II, but it is adapted to the characteristics of the crowdfunding market. So as a result, those two distinctions coincide in many elements, but are not identical. If you will go through the regulation and the definition of sophisticated investors, for instance, in the definition, we will see that the definition refers to the MiFID II, but deploy also some extra criteria. And based on those categorization, we have different protection mechanisms for those different types of different categories of investors. And yeah, I would say that I identify four main mechanisms: entry knowledge test, simulation of the ability to bear loss, key investment information sheet, and cooling off period. And I would say that those three first ones, they to some extent they are like quite typical for protection in the financial markets, and there are in detail some differences, but in fact the mechanisms are similar to those which are implemented to the traditional financial market in MiFID II. But what is quite new, and I want to focus today more about on this mechanism, is cooling off period. Yeah, the article 22 of the regulation states that the prospective non-sophisticated investor may at any time revoke his or her offer to invest or expression of interest in the crowdfunding offer without giving a reason or without incurring a penalty. And there is date that the cooling off period should expire after 4 calendar years, and it's a minimum period of time. In practice, many crowdfunding platforms provide a longer cooling off period. And why I think it's quite an unusual or interesting implementation of this protection mechanism is that cooling off periods are typical mechanisms for consumer protection law. Yeah, this legal institution is widely used in e-commerce, but also in some jurisdictions applies, among others, to time sharing or insurance service. Although it hasn't, although it has been applied to some particular financial products over the years, the cooling off period wasn't applied to investing as such widely. And in literature, we can see that the reason or the explanation were why cooling off periods weren't used widely in investment transactions. It was because legislators were fear of potential usage of cooling off period for speculation purposes on the stock market. So there is a, let's say there is a risk that some financial consumers could benefit from the ability to withdraw after a few days from the investment in case the share price went down after the investment. However, in equity crowdfunding investment, that share price fluctuations are much minor if those fluctuations occur at all. Yeah, are quite minor in comparison with public stock markets. The company sets out the share price on the crowdfunding platform based on the company's valuation. As equity crowdfunding investments are characterized as highly illiquid, and the secondary markets for equity crowdfunding is much less developed than in traditional public markets, the share price of crowdfunding project is much less volatile from a short-term perspective. So consequently, it should be claimed that the risk of speculation in equity crowdfunding is relatively low and shouldn't be considered as an obstacle in implementing a cooling off period in equity crowdfunding markets. The cooling off period aims to protect the weaker side of the contract from manipulation and abuses from the stronger side, which distinguish itself from a professional nature in a particular transaction. And yeah, in the literature, it is often highlighted, there are often highlighted two main functions of cooling off period. It's reducing information asymmetry, and second, preventing the consumer from the consequences of the decisions made under psychological pressure. And yeah, those two functions can be straightforwardly observed in the example of distance selling, which we probably we all are aware, or that's the first thing which we about which we think when we hear cooling off period, when the consumer is receiving a product that he or she couldn't verify in person before making the decision to buy it or not. The distance between the consumer and the seller creates an asymmetry of information, which is reduced by giving the consumer a chance to resign from the transaction after receiving that product and verifying it in person. Purchasing on internet can also create a psychological pressure, as e-commerce websites use aggressive marketing tools and so on and so forth. The question arises if the same two functions will be performed by cooling off period in applying this mechanism to equity crowdfunding. Undoubtedly, crowd investors are prone to incentives that significantly impact their behavior and can create psychological pressure. The most widely described in the behavioral finance research on this type of financing is a phenomenon called wisdom of the crowd. Crowd investors, especially non-sophisticated ones, have a strong preference to invest in projects that have already collected the vast majority of targeted amount of capital. Commonly, crowdfunding platforms present progress in raising funds with visual graphics highlighting how much is already collected and how close is it to reach the target or even become overfunded. As behavioral finance research shows, non-sophisticated investors have a strong preference for projects that have already reached the target. Thereby, the non-sophisticated investors mainly are following the crowd. In addition, crowd investors receive regular notification about passing time to invest in particular project, which increase pressure on them. That is why I think implementing a cooling off period for non-sophisticated crowd investors to minimize the negative consequences of investment decisions made under psychological pressure seems justified. More questionable is if the cooling off period in equity crowdfunding addresses the information asymmetry issue. In the distance selling example, it was obvious. Consumers, through the cooling off period, were able to verify the product in person, so they were obtaining extra information about the product, which they had not possessed at the moment of making purchase decision. In the case of equity crowdfunding investment,
sorry for interrupting you. You're running out of time, so could you maybe just try to wrap it up in the next minute or so?
And the cooling does not contribute any new information about the company or offered share. So to conclude, equity crowdfunding brought a new type of investors to financial markets. Consequently, EU regulation introduced a new classification of investors, which differs from the categories which we know from MiFID II. The majority of crowd investor protection mechanisms reflect those already found in the capital markets, mainly for retail clients. However, the novelty is this cooling off period. And I would say the higher level of crowd investor protection and well-established consumer protection mechanism introduced to the capital markets prove that non-sophisticated investors should be considered as one of the most vulnerable groups in the financial markets. And maybe last sentence of the conclusion is that investing is inherently risky, and the law certainly cannot guarantee positive returns, but the protection mechanism should enable secure and stable market conditions for the most vulnerable and inexperienced investors who are dominating crowdfunding markets. Thank you very much.
Thank you for your presentation. I kind of get the feeling that differences in investor protection between crowdfunding and trading on the regular market are coming closer and closer. I mean, there should be less differences. And I have a feeling that such approximation will not only be a one-way street with time, but a two-way street. But I can't but wonder, could this issue of cooling off period work in fast-paced transactional trading on the regulated market? Well, I'm looking forward to reading your paper on the issue. So thank you very much. And we have come to the end of our presentations at the first panel of today. And we have some small time for questions, comments from the audience, if there are any. Feel free to join in and pose a question to our presenters.
I think I have one question from Edita. Yeah, I would like to give answer. First of all, I would like to thank to Edita for this question, which gives me an opportunity to clarify one important point about AI directors. As a matter of fact, as claimed by many experts, scholars using AI director may create an accountability gap. And in detail, I can say that even if we use one AI director, this might result in another serious issue, in that other human directors may become interrupted in their views of artificial intelligence. So using an AI director might help organizations to make better decisions, as I said in my presentation. As Carr et al. Argue, it also poses difficulties linked with the dark side of AI. One of the key reasons for this is the prospect that AI appointed as a manager may be able to influence the opinions of other managers, other directors. Therefore, by thinking that the AI director is a machine learning algorithm and has intelligence, more intelligence than humans, human directors may abandon their own decisions and apply AI decisions in every field. So company directors are defining each country's own corporate law rules and duties, and responsibilities of these directors towards the company are laid down in the provisions of those rules. When considering AI as a manager, even if the AI obeys the above provisions and makes decisions, other managers need to detail their own views instead of following the AI's views. The challenge is in determining whether human managers will use whatever information they get from the AI machine rather than detailing and utilizing their personal and professional judgments. So it will not be easy to determine this issue. Even the managers themselves may not realize this and may blindly follow the views of AI. So as a result, even one AI director is appointed to corporate boardroom, this might create an accountability gap and a dominant opinion among the company's management. Those precautions should be taken, and it also appears to bear the risk of directors relying on unaccountable subjects' opinions. Thank you very much for this question again.
Thank you for your answer. Do we have anyone else with a possible question? I guess we do not have anyone. So if we do not have any further questions, I'm turning over to Zvonimir to conclude this final panel session. To conclude this first panel session, and I believe that we have a break incoming within the next few minutes. Zvonimir?
Thank you, Tomislav. So I will close this session, and now we have a break until the noon, and then we will proceed with the next thematic session. Thank you everyone for discussions and contributions.
Thank you.